A serving member of the British Armed Forces contacted me to discuss his journey through the family court. What he said caught my attention when he stated that family court district judges need to grow a spine. I looked up the commonly used urban definition of growing a spine, and it states, to grow a backbone, to have courage and confidence, not to let people walk over you. So I have decided to examine his story and to then, based on balance of probability, come to a judgment as to whether family court district judges need to grow a backbone. But just before I do, let's run my excellent introduction. I am Philip Kedge, a retired police chief inspector and director of the McKenzie Friend UK network. I have been a McKenzie Friend for a decade and founder of the National Family Court campaign of #LightNotHate, stopping harm to children. In my blogs, my views and opinions are entirely my own, and please help me by liking this blog, subscribing to the channel, and please hit that notification bell. On with the story. I shall refer to this gentleman who contacted me as Corporal Jones. I'm not suggesting what military service he is in, or indeed that he is a corporal. It is just that Corporal Jones is synonymous with the phrase, don't panic, which is apt, because that is what I frequently tell my clients. So, Corporal Jones informed me that he has recently completed his final hearing with respect to child arrangements. He self-litigated and presented a reasonable, balanced and child-focused case, as opposed to his ex, who tried everything in the book to sling mud, raise issues and hinder the contact process. That doesn't happen very often, does it? At the final hearing, the judge ordered the standard contact of every other weekend and half the holidays, with some variations to support his service duties. So what's wrong with that then? All is well, that ends well. At the first hearing, the judge ordered both parties to attend the SPIP, the Separated Parents Information Programme. This programme helps parents understand that parental conflict and acrimony harms their children. Attending this course is a requirement, particularly when it is court ordered. Corporal Jones fully complied and stated that he benefited from the course. However, on attending the next hearing, the mother had not completed it. The judge was not very pleased and reminded the mother that this was court ordered and compulsory to attend. He again ordered her to do the SPIP course. I think you can now guess where this is all heading. 3 months later, and what should have been the final hearing had to be changed to another interim directions hearing due to the mother's ongoing resistance to contact. Corporal Jones described the process as continually having to take 1 step forward and 3 steps back. I'm sure that this will resonate with many of you watching this blog. He was doing the right thing, not panicking, not slinging mud back, and being the bigger parent. But once again, the mother had not completed the SPIP. The judge responded by being very cross with the mother. And after being very cross, the judge gave directions to resolve the problems and to set a new date for the final hearing. The mother was for the third time ordered to complete the Separated Parents Information Programme. The day of the final hearing arrived, and of course she hadn't completed it. This is a mother who believed that attending parenting classes was beneath her. Of course she wasn't harming her children. She is their birth mother, their protector, the naturally gifted, wise and righteous one. How dare a judge tell her how to parent and how to promote parenting with a course? At the final hearing, and after 9 months of putting the children and the father through hell, she was dragged kicking and screaming into a position where the judge gave a final order. The order was for the children to spend time with their dad every other weekend and half the holidays. An outcome that quite frankly should have been put in place from day one without any court intervention whatsoever. In his judgment, the judge expressed disapproval in relation to her having not completed the SPIP. And that was it. Disapproval, with a few tuts and shakings of the head. It was clearly all too difficult. Time to get rid of this case and on to the next one. No sanction, no penalty, no nothing. This now brings me to the point where I have to apply the family court standard of balance of probability to determine the question whether family court district judges need to grow a backbone. What is interesting in relation to this judgment is that the question is not whether this particular judge needs to grow a backbone, but whether collectively all family court district judges need to grow a backbone. In order to determine this, I have to consider, given this scenario, what would the majority of family court judges do? Would the majority also turn a blind eye and do nothing about a parent breaching the order on 3 occasions to attend the SPIP? This is my judgment. Based on my experience of over 10 years in the family court, it is my judgment that the vast majority of judges would fail to take any positive action given this scenario. My perception of family court district judges is that when it comes to breaches of orders, that they lack presence, they lack authority, and they all too often demonstrate a total unwillingness to act. They adopt a laissez-faire attitude, sitting back, not wanting to get involved, not wanting to push any buttons, not wanting to rock the boat, not wanting to upset the resident parent. I have absolutely no hesitation in coming to a judgment that family court district judges across the entire family court system need to grow a backbone. And I am now going to explain why this is so very important. In this case, the mother walked out of court laughing at the system. She demonstrated to the court that she was more empowered than the judge. She determined that her parenting did not require attending the SPIP, and the court capitulated. She repeatedly and intentionally broke the court order and was allowed to do so. She defied the court and became the authority figure, and the court cowered in its response. What an absolute shameful disgrace. When parents enter into the family court system, they do so believing that the system is fair, that there are rules that have to be followed. There are court orders that, if broken without any reasonable excuse, carry a penalty. Good, honest, law-abiding people entering into the family court system believe that court orders are of absolute importance and carry the weight of the crown behind them to apply the justice that is expected and required. When court orders turn out to be pointless bits of paper that carry no authority, no weight, no intended consequence for non-compliance, the family court system collapses, which is pretty much where it currently finds itself. A totally broken and unfit for purpose system. So what about Corporal Jones? Well, he joins the tens of thousands of people each year who have to endure the painful, pitiful and inept family court system. One more person added to the endless list of those who have lost all confidence in the family courts, and they are totally justified in their views. So, why can the courts continue to get away with it? Family court judges hide behind their benches, sitting under the royal coat of arms with the phrase Dieu est mon droit, God is my right, whilst all too often failing to uphold the principles of fairness and balance that our nation's royal coat of arms demands. They know that they can get away with it because there is no transparency within the family courts. No one will ever know. Parents are gagged from talking publicly about their experiences with threats of imprisonment for contempt of court. The free press that our nation relies on for the democratic checks and balances is denied access into family courts. Judges can simply hide away without any threat of public scrutiny. Look, I have no personal axe to grind, no drum to beat. I am just telling people what I have observed from my 10 years of experience. Tens of thousands of people are listening and understanding exactly what I am saying because they recognise it and have experienced it. In conclusion, the family court is a hidden, cloaked and masked establishment that hides itself away from any public scrutiny or accountability and is totally out of touch with the people it claims to serve. This is not justice. This is a blight on our justice system, and as a McKenzie Friend, I am very happy to be one of the first people to actually explain what is going on so that we can at least start to empower ourselves to call for change and to be able to express our own judgments on a system that judges us. I would be so grateful for just 30 seconds more of your time. I hope that you are enjoying all of my blogs on my channel. I would like to invite you to take a tour of my family court training modules at familycourttraining.co.uk. The fee for the training is similar to what you would pay for 30 minutes with an unnecessary lawyer. Perhaps it's time to truly empower yourself in relation to all aspects of your family court case and to take the solutions-based approach that I teach for the sake of your children. Alternatively, perhaps you want to become a McKenzie Friend to assist others and potentially create an amazing new income stream. You have nothing to lose by putting familycourttraining.co.uk into your browser and taking a look right now.